Dear students, we have with us today a very special guest, the Honorable Judge of the Supreme Court of India, Justice Ujjal Bhuyan. A warm welcome to you, sir. I, on behalf of University of Science and Technology, Meghalaya, path in the field of law and justice. Honorable Bhuyan sir's started acumen led him to hold several prominent posts throughout his career, various legal associations. Career as a judge began when he was appointed as an additional judge of the Guwahati High Court in 2011.
A very good morning to all of you. I'm very happy and rather pleasantly surprised by the university, the infrastructure which has come up in the university. This auditorium is a wonderful auditorium, and the best part of the auditorium is that there are no pillars in between to obstruct the views. So, and it's a beautiful acoustics we have here. So it's very nice and a pleasant surprise for me to be here in USTM University. In fact, I'm very happy to be present here today. At the outset, I must congratulate all those associated with the USTM University for the phenomenal growth of the university. A university is not only a place of higher learning, but it is a place where youthful minds interact and blossom. New thoughts, new ideas germinate in the campuses of the universities, uninfluenced by the complexities of the real world outside the campus. I'm confident that in due course of time, USTM University will become a leading center of knowledge, not only in the country, but its name and fame will spread beyond the frontiers of the country. Friends, when I last visited Guwahati in May 2023, in between I had come once, I got an invitation to visit this university. But because of prior commitments at that point of time and time constraints, I could not come here. So when Professor Rajkua asked me if I can visit the university this time around, I immediately said yes. And I think I made a good decision to come here to share my views on a very contemporary subject with our students and, of course, the faculty. But before that, I must, the Chancellor has said that the large proportion of the students are girl students, and the large proportion of faculty are also women faculty members. This is a very, very welcome sign. In fact, this is the trend in the judiciary that we have noticed. I can say at least for 3 high courts with which I was connected, still I am connected, Guwahati High Court, Bombay High Court, and the High Court for the state of Telangana. In all the 3 high courts, I have noticed that entrants into the judicial service of the respective states are more than 50%. We talk about women's reservation, the 33%, but they have crossed more than 50, 60, 70%. In fact, the Chief Justice of the Guwahati High Court, Justice Mehta, he told me that in Rajasthan, in the recent batch, 70% are lady judicial officers. So these are all welcome developments, and this only shows the inclusivity of the legal education and the justice system in which we are progressing. The topic of today's deliberation, I say, is very extremely crucial. We are going to discuss today about our Constitution and how it has shaped the concepts of equality and democracy. But before that, there's a disclaimer. I'm not here today as a Supreme Court judge. deliberating upon this topic. I am here today as a student of law, having an abiding faith and belief in the Constitution of India. Friends, India attained independence on August 15, 1947. The Constituent Assembly was in session. Drafting committee of the Constituent Assembly, led by Dr. Babasaheb Bhimrao Ambedkar, after several rounds of intense debate and discussions, drafted the longest written constitution in the world, having 395 articles, which was adopted by the Constituent Assembly on November 26, 1949, and came into force on and from January 26, 1950. There are several features, salient features of the Constitution, if you may name any of them. Wherever I go, I ask my audience, who are mostly students, as to which of the provisions of the Constitution, according to them, are the most important. You are also attending your Constitution classes. Your teacher must be asking you. Some would say preamble to the Constitution of India. Others would say Articles 14 or 19 or 21. I entirely agree with each of them. While the preamble is the mirror to the Constitution, Articles 14, 19, 21 not only form the golden triangle, but these articles are the heart and soul of the Indian Constitution. 14 speaks about equality. We'll deal with this. 19 is about fundamental freedoms, while Article 21 is about life and liberty. Each of these articles form the essence of the rule of law. But these articles would remain relevant and important so long as the Constitution is in place. Only if the Constitution is in place, these articles 14, 19, 21 will remain relevant. For these articles to flourish in the truest sense, it is necessary that the Constitution retains its basic elements and not get replaced by another constitution altogether. It is in this context that Article 368 of the Constitution of India, which deals with the power of Parliament to amend the Constitution, assumes great significance. In your Constitution classes, certainly you will go through this article and all the judicial pronouncements centering around this article. As we shall see, Supreme Court, by interpreting this article, has ensured that Articles 14, 19, and 21 and similar other provisions remain embedded in our constitutional jurisprudence. I am reminded of Granville Austin, a scholar and a critic of our constitutional journey. He has described the Constitution of India as a social document, the primary objective of which is to build a democratic and equitable society. It's a dynamic document, and when framed, was far ahead of its time, a progressive document superimposed on a highly feudalistic society. I would say, even now, certain provisions of our Constitution are far ahead of its times. Our Constitution strikes at inequality, at an unjust and unequal social order. Essence of our Constitution is equality between men and between men and women. It seeks to establish a humane and just society. It is indeed a transformative document. Friends, you must have already in your classes gone through several times the preamble to the Constitution of India. It is necessary that we go through this preamble every day. And whenever you go through the preamble, you will get a new vision, you will get a new understanding every time you read the preamble. So I have kept on my table, it was gifted to me by one of my colleagues in Bombay, a framed preamble of the Constitution of India. The crucial words, I'm not going to read the entire preamble, the crucial words appearing in the preamble are justice, which includes social, economic, and political, then liberty, liberty of thought, expression, belief, faith, and worship, equality. Again, we'll discuss about this. Equality of status, opportunity, and fraternity. That is the dignity of the individual, coupled with the unity and integrity of the nation. Now, if you look at the preamble indicates the source from which the Constitution comes. The preamble says, we the people of India have given to ourselves the Constitution. These words emphasize the republican and democratic character of the polity, and that power ultimately stems from the people. In India, therefore, if you look minutely at the preamble, people are supreme through the Constitution of India and not the elected representatives. We'll come to this aspect again when we speak about constitutional supremacy as opposed to parliamentary sovereignty. Preamble therefore contains the ideals and aspirations or the objects which the Constitution makers intended to be realized by these provisions. In Keshavananda Bharati's case, it was a case decided by 13 judges. Majority, that is 7, held that unlike preamble in an ordinary statute, in an ordinary law, preamble to the Constitution should be interpreted as a part of the Constitution. The majority held that objectives specified in the preamble contain the basic structure of the Constitution, which cannot be amended in exercise of the power under Article 368 of the Constitution. We then come to Article 14, which has got two components. One is equality before the law, and the next component is equal protection of the laws. At the first blush, these appears to be routine, mundane expressions. But these expressions have got immense meaning, and which are the essence of our Constitution, which form the fulcrum of the rule of law. Equality before law, it is actually taken from the English common law. It's a declaration of formal equality of all persons within the territory of India. It implies absence of any special privilege in favor of any individual. It was Dr. Thomas Fuller, an English physician and an intellectual, who had said more than 300 years ago that be you ever so high, the law is above you. This is the essence of Article 14, and this finds its echo in the above expression. Equal protection of the law means amongst equals, the law should be equal and should be equally administered. Likes should be treated alike, and it forbids discrimination between similarly placed persons. Article 14 is the heart of the Constitution. It is the essence of the rule of law. Though Article 15(3) acknowledges the vulnerable position of women and children in India and permits special legislation for such vulnerable sections. So also Articles 15(4) and 16(4), which advances the cause of social justice. But the golden thread running through this article is the essence of equality. In fact, the rule of law is a basic feature of the Constitution. Rather, I would say equality itself is one of the basic features of the Constitution. As we proceed, we shall discuss this more in detail. Friends, in the initial stages, the view of the Supreme Court regarding amendment of the Constitution, be it Sankari Prasad Singh or in Sajan Singh, the view was that any part of the Constitution is amendable. No part of the Constitution was unamendable. Parliament may, by passing a Constitution Amendment Act in compliance with the requirements of Article 368, could amend any provision of the Constitution, including the fundamental rights and Article 368 itself. The break came for the first time in Goloknath's case. In Goloknath versus State of Punjab, at that point of time, it was the largest bench in the Supreme Court. 11 judges sat on the bench, and by a majority of 6 to 5, overruled all the previous decisions and held that though there is no express exception from the ambit of Article 368, fundamental rights included in Part 3 of the Constitution could, by their very nature, not be subject to the process of amendment provided by Article 368. If such a right was to be amended, a new Constituent Assembly should be convened for making a new Constitution or for radically changing it. Supreme Court held that while the Parliament had the power to amend any part of the Constitution, it could not amend or alter the fundamental rights. Parliament's amending powers were not unlimited. Any constitutional amendment infringing upon fundamental rights would be unconstitutional and invalid. That's the view taken in Goloknath. In the 50s and 60s, a series of land reforms were introduced in what is now the state of Kerala. The objective of these reforms was aimed at redistributing lands belonging to large landowners to the landless and to the poor. In fact, the Kerala legislature enacted the Kerala Land Reforms Act, which put a cap on the area of land which a person could hold. And in 1970, this limitation was extended even to religious institutions. A religious institution could not hold beyond certain limit of land. Keshavananda Bharati was the head, or we may call pontiff, of a particular mutt in Kerala. The mutt had large tracts of land. He challenged the constitutionality of the aforesaid act before the Kerala High Court, from where eventually the matter came to the Supreme Court. In the meanwhile, Parliament of India passed the Constitution 24th Amendment Act 1971, amending Articles 13 and 368, by which it was clarified that Article 13 would not apply to any amendment of the Constitution under Article 368. And that Parliament, in exercise of its constituent power, can amend any provision of the Constitution in accordance with the procedure laid down in Article 368. Thereafter, there were two more amendments of the Constitution, the 25th and the 29th, which sought to limit the fundamental rights of citizens qua land and making the amended provisions immune from judicial scrutiny by placing those enactments into the 9th schedule. The obvious reason for introducing these amendments was to supersede the majority decision in Goloknath. As per the amendments, firstly, such an amendment of the Constitution would not be a law as understood under Article 13. Secondly, validity of a Constitution Amendment Act would not be open to question on the ground that it takes away or affects a fundamental right. These amendments also came to be challenged by Keshavananda Bharati, which gave rise to one of the most celebrated case of India's constitutional history, Keshavananda Bharati versus the state of Kerala. This year we are celebrating 50 years of this judgment. In fact, last month when I came to the National Law University in Guwahati, I delivered a talk on the Keshavananda Bharati case. This case was heard by 13 judges, a bench of 13 judges. And there was only one question, simple question, that the bench had to answer. Whether exercising power under Article 368 of the Constitution, the Parliament could amend any part of the Constitution. That was the question. 13 judges. There was a tie, 6-6. Justice H.R. Khanna, who was a member of the bench, broke the tie, and his opinion became part of the majority decision. The majority held that Article 368 did not admit of any implied limitation on the amending power of the Constitution. The very meaning of the word amend leads to the following limitations. I'll just quote. While any piecemeal change may be made, the old Constitution cannot be totally destroyed or so radically changed as to lose its identity. Hence, the basic structure or basic features of the existing Constitution cannot be amended through the process of amendment as provided in Article 368. The amendments were held to be valid, and the decision in Goloknath was overruled. Now, this decision in Keshavananda Bharati was explained very succinctly by a 7-judge bench of the Supreme Court decades later in M. Nagaraj versus Union of India. That was a case where constitutional validity of certain amendments providing for reservation and promotion with consequential seniority was challenged. The challenge was, the question falling for consideration before the court was whether such reservation in promotion violated the right to equal opportunity in public employment, thus violating the right to equality, which is a part of the basic structure. Supreme Court in M. Nagaraj examined the theory of basic structure in the following words. I just quote it, extract it. The theory of basic structure is based on the concept of constitutional identity. Students of constitutional law, please note these words. theory of basic structure is based on the concept of constitutional identity. The basic structure jurisprudence is a preoccupation with constitutional identity. In Keshavananda Bharati, it has been observed that one cannot legally use the constitution to destroy itself. Personality of the constitution must remain unchanged. While propounding the theory of basic structure in Keshavananda Bharati, Supreme Court relied upon the doctrine of constitutional identity. The word amendment postulates that the old constitution survives without loss of its identity, despite the change, and it continues even though it has been subjected to alteration. This is the constant theme of the opinions in the majority decision in Keshavananda Bharati. To destroy its identity is to abrogate the basic structure of the Constitution. This is the principle of constitutional sovereignty, which I said. The main object behind the theory of constitutional identity is continuity, and within that continuity of identity, changes are admissible depending upon the situation and circumstances. As we have already noticed earlier, 7 judges in Keshavananda Bharati held that the objectives specified in the preamble contain the basic structure of our Constitution, therefore, the preamble cannot be amended in terms of exercise of the power of Article 368. Mr. Nariman, Fali Nariman, many refer to him as the conscience keeper of Indian judiciary. He has written in his book, Before Memory Fades. I think aspiring lawyers should read this book, Before Memory Fades. He has referred to this Keshavananda Bharati case and the controversies surrounding it. He says in his book that it was only a day before Chief Justice Shri retired that the entire court, at that time court had 13 judges, had assembled to announce its decision. As many as 11 judgments were handed down by 13 justices. The judgments were very erudite, but short on clarity, Nariman says. However, the underlying thread through all the opinions was in favor of Parliament having the power to amend any provision of the Constitution, but in the process could not destroy or alter any basic feature. As summary, H.R. Khanna produced or prepared a summary of the final order, which was signed by 9 of the 13 judges. This statement of 9 judges is also referred to in his book, Working a Democratic Constitution, The Indian Experience by Granville Austin. Friends, though the central government should have been very happy with the verdict outcome of the case, because the majority had overruled Goloknath and had upheld the amendments, nonetheless, the government was certainly not happy with the basic structure theory propounded in Keshavananda Bharati. In fact, the view taken was that by propounding this doctrine, which has become the bedrock of constitutional interpretation in India, the freedom of the government to effectively employ amendments to amend the Constitution was drastically reduced. Therefore, despite the ostentatious victory in the litigation, the government treated it as a legal defeat. Now, friends, this Keshavananda Bharati judgment has not come in a vacuum. It did not come in all of a sudden. Things were brewing up over several years. In fact, this case was the culmination of a serious conflict between the judiciary and the executive government headed by Mrs. Gandhi at that point of time. In 1967, Supreme Court took the rather extreme view in Goloknath that Parliament could not amend the fundamental rights. 2 years later, Mrs. Gandhi nationalized 14 major private banks in the country for paltry compensation payable in bonds maturing after 10 years. In R.C. Cooper, this was struck down by the Supreme Court, although it upheld the right of the Parliament to nationalize banks and industries. Next year, the government abolished the privy purse provided to the princely states. This was challenged in the Supreme Court by Madhav Rao Scindia. This was also struck down by the Supreme Court on the ground that it was a constitutional betrayal of the assurance given to the erstwhile rulers of the princely states by Home Minister Sardar Patel. Interestingly, all these three cases were argued on behalf of the petitioner by the great constitutional expert, Mr. Palkhiwala. Ultimately, the government brought in a series of constitutional amendments to undo Goloknath, to undo bank nationalization, to undo privy purse. And this led to the famous Keshavananda Bharati case. Incidentally, this was also argued by Mr. Palkhiwala. This doctrine has been criticized very severely by very many people, not only from the executive, some within the judiciary, some from the legislature. It has been criticized as anti-democratic. Instead of parliamentary sovereignty, it propounded constitutional sovereignty. Some even went to the extent of describing it as a judicial coup. The criticism continues. I will not elaborate on this. Those who are following, they follow. The criticism continues till date. Now, friends, since we are on a constitutional journey, another interesting development was taking place at that point of time. Mrs. Gandhi's election to the parliament from Raebareli constituency in UP was challenged by her detractor, Mr. Raj Narayan, by way of an election petition before the Allahabad High Court. In the election petition, Raj Narayan alleged that Mrs. Gandhi had indulged in corrupt practice, thus violating provisions of the Representation of the People Act, 1951. After a prolonged hearing, intercepted by petitions to and fro to the Supreme Court, finally Justice Sinha of the Allahabad High Court delivered his catalytic judgment on June 12, 1975. By this judgment, he declared the Prime Minister's election as void and nullified the same by holding that she was guilty of corrupt practice in her election campaign. The corrupt practice was she had used the services of state and central government officers in her campaign. When this was challenged before the Supreme Court, it was then in vacation. It was June, vacation. Mrs. Gandhi this time turned around and sought the assistance of Mr. Palkhiwala, her legal adversary. In a series of cases, she turned to Palkhiwala. Palkhiwala was assisted by the great Nariman, both from Bombay. They filed the SLP in the vacation bench and sought unconditional stay of the High Court judgment. The vacation judge was Justice Krishna Iyer. He heard the matter for a whole day, and the next day, he pronounced his interim order. He granted a conditional stay, ruling that electoral disqualification stood eclipsed during the stay. Prime Minister Gandhi could address Parliament, but she could neither participate nor vote in the Lok Sabha debates, nor draw remuneration as a member. 2-3 days later, emergency was declared in India. During this period, government introduced several amendments to the Constitution. The highlight of these amendments was that election to high offices like President, Vice President, Prime Minister and Speaker should be immune from judicial scrutiny, and in case of a dispute, it should be decided or adjudicated by a body to be established by the Parliament, which was not declared or established. These amendments were also challenged in Indira Nehru Gandhi versus Rajnarayan. By Mr. Rajnarayan, he challenged this, and by several others. In Indira Nehru Gandhi versus Rajnarayan, Supreme Court upheld the election of the Prime Minister. This is because the electoral disqualification were removed by way of statutory amendments in the Representation of the People Act. So these were no longer infringements or violations of the RP Act. But the Supreme Court annulled all these constitutional amendments, holding that certain features of the Constitution, like free and fair elections, rule of law, or abolishing judicial determination of an election dispute without affording an alternative forum, could not be altered. These are basic features of the Constitution. Unlike Keshavananda Bharati, which was a split verdict, 7:6, this judgment was unanimous. All 5 judges of the Constitution bench, including 4 who had given the minority dissenting judgment in Keshavananda Bharati, this time applied the basic structure theory and annulled the amendments. 3 days after this judgment was delivered, there was an attempt to review Keshavananda Bharati. I will not go into that for time constraints. Chief Justice A.N. Ray had convened a 13-judge bench to review the doctrine of basic structure. There is a very interesting book. If you have the spare time, please go through this book. It is titled The Keshavananda Bharati Case, The Untold Story of Struggle for Supremacy Between Supreme Court and Parliament. It has been written by late Mr. Andhyaru Jina, who was one of the lawyers in that famous case. He was a senior counsel in the Supreme Court, Advocate General of Maharashtra, and later on Solicitor General of India. In that case, he argued as a junior counsel assisting Mr. Sirvai, who appeared for the state of Kerala. Now this review attempt, I'll just try, because this lingering objection or opposition to the basic structure theory still continues till date. Therefore, it is essential that we briefly touch upon the abortive attempt to review Keshavananda Bharati. Chief Justice A.N. Ray had passed a written order on October 20, 1975, that the court would hear on November 10, 1975, 2 questions. Number 1, whether the basic structure theory or doctrine restricted Parliament's power to amend the Constitution. And secondly, whether the bank nationalization case was correctly decided. He has written in his book that there was no application before the Supreme Court or before the Chief Justice of India seeking a review of Keshavananda Bharati. No hearing had taken place. So he posed a question for on what basis this order came to be passed on October 20, 1975. As scheduled, the hearing commenced on November 10, 1975. Palkiwala opposed, stood up and appeared to oppose the review. Mr. Andhyarujuna has given a vivid description in his book as to how things unfolded. He has described as to how Palkiwala argued on those 2 days. Firstly, he had argued that no case was made out to review the basic structure theory. It was most inopportune to review Keshavananda Bharati decision during the emergency. But it was his argument about the consequences of unbridled power of amendment of the Constitution if the limitation of basic structure was revised by the court, which had a powerful impact on the bench. Mr. Andhyarujana writes in his book that Palkiwala argued that afternoon, November 11, 1975, with great force and eloquence, holding the court and those present spellbound. Though he was at all times a master orator and a skillful advocate, his arguments on that afternoon were something which those present could never forget. Justice Khanna was also a part of the bench, both in the original Keshavananda case and also in the review. In his memoirs, Neither Roses Nor Thorns, has also written about the height of eloquence reached by Palkiwala on that day. And he says, this may never be surpassed in the Supreme Court, annals of the Supreme Court. Both Professor Upendra Bakshi and Granville Austin, they have made a scathing commentary on the attempt to review Keshavananda. I need not go into the details of the criticism, but both of them wrote about the arguments or the eloquence reached by Palkiwala that particular afternoon. In fact, Granville Austin also writes that Palkiwala was so perturbed, so disturbed, that he wrote a letter to the Prime Minister beseeching her not to press or go ahead with the review petition. Now, of course, Austin criticized the propriety of Palkiwala writing a letter to the Prime Minister to the opposite side to withdraw the review petition, but nonetheless, he has written about this to highlight the apprehensions expressed all across about the consequences which may befall on the country in the event basic structure theory is recalled or reviewed. Now, friends, that was 1975. This judgment of Keshavananda Bharati, as was followed in Indira Nehru Gandhi, has subsequently been applied by the Supreme Court in more than a half a dozen cases. Constitution benches, some benches of 7 judges, some benches of 9 judges. It was Minerva Mills, Union of India, you may recall, Vaman Rao, Union of India, Coelho versus State of Tamil Nadu, one after the other. Benches of 5 or more had upheld and applied the doctrine of basic structure. Now, according to Granville Austin, he beautifully describes this situation, which he says, by evolving the doctrine of basic structure, Supreme Court had reaffirmed that checks and balances are vital to the preservation of democracy and of the fundamental rights. He has put it very beautifully by saying that Keshavananda had propounded the doctrine Indira Nehru, Gandhi had upheld it, and Minerva Mills has engraved it on stone. Many commentators question this approach, saying that no judicial principle should be engraved in stone. One generation cannot tie down future generations to its interpretation of the law and constitution. But friends, this is just like beating around a bush. It is now the law of the land in this country. As I said, more than half a dozen constitution benches have applied this doctrine. Now, the interesting part is this: Keshavananda did not foreclose the list of basic structure, or what could be the basic structure. Shri said that republican and democratic form of government are basic features of the constitution. Yashwant Chandrachud also said in Indira Nehru Gandhi these two features. Now, in the anti-defection case, Quixote Holohorn versus Judge Hilhu, Supreme Court declared that democracy is a basic feature of the Constitution, and free and fair elections conducted at regular prescribed intervals is essential to the system envisaged in the Constitution. Now, the basic structure concept was also applied in S.R. Bommai versus Union of India. In this case, there were no question of constitutional amendment was involved. Several state governments earlier to Babri Masjid demolition were dismissed by applying Article 356. Post Babri Masjid demolition, several state governments were dismissed. All these questions came up for consideration in S.R. Bommai. In S.R. Bommai, Supreme Court has held that secularism is an essential feature of the Constitution and a part of the basic structure. It was also observed that democracy and federalism are essential features of our Constitution and part of the basic structure. The list goes on. In L. Chandrakumar, for example, Supreme Court has held, this was in the context of the Administrative Tribunals Act, Supreme Court has held that independence of the judiciary is a basic feature of the Constitution. It is the sine qua non of the democracy, being the most essential characteristic of a free society. Judicial review has been held to be a basic and essential feature. If the power of judicial review is abrogated or taken away, the Constitution will cease to be what it is. As recently as in 2016, in the Supreme Court Advocates on Record Association versus Union of India, Supreme Court struck down the Constitution 99th Amendment Act 2014 and the National Judicial Appointments Commission Act 2014, providing for a National Judicial Appointments Commission, NJAC, replacing the collegium system for appointment of judges to High Courts and Supreme Court on the ground that those impinged upon the independence of the judiciary and were also violative of the principle of separation of powers between the executive and the judiciary, which formed the basic part of the basic structure of the Constitution. So therefore, friends, as things stands today, as long as this decision in Keshavananda Bharati holds the field, and mind you, this is a judgment of 13 judges, this is the law of the land, and no amendment of the Constitution would be immune from challenge on the ground that it affects one or the other of the basic features of the Constitution. Friends, we have seen how the law has developed by way of interpretation. We have also seen that equality and democracy are now considered and held, established as basic features of the Constitution. Let me elaborate a little on the two concepts, equality and democracy. When we talk about equality, the discourse will be incomplete if we don't talk about Dr. Ambedkar. In the early decades of the 19th century, there was an organization in the Punjab called Jat Pat Torak Mandal. As the name suggests, the objective was to break the caste barriers prevalent in the society. In 1936, this organization wanted to hold its annual conference at Lahore, and for this, they made Dr. Ambedkar the president of the conference. When Dr. Ambedkar sent a copy of the presidential address, which he had printed, prepared, to the members of the reception committee, they developed cold feet. They found certain portions of the speech to be objectionable, though they were very well aware about Dr. Ambedkar's views on the caste system. Perhaps for this reason, the annual conference was cancelled. Dr. Ambedkar published this speech prepared by him in the form of a book which he titled Annihilation of Caste. Government of Maharashtra, Education Department, Government of Maharashtra has published this book in the collected and finds place in the collected writings and speeches of Dr. Ambedkar, Volume 1. 1979, it was published when Mr. Sharad Pawar was the Chief Minister of Maharashtra. In this article, Dr. Ambedkar completely repudiated the caste system as well as the Chatur Varna system, between which he did not find, or rather did not ascribe, any distinguishing feature. He propounded the view that political reform could not take precedence over social reform. Adverting to the social reforms being undertaken by liberated and enlightened Indians like Raja Ram Mohan Roy, he was of the view that it was necessary to make a distinction between social reform in the sense of reform of the Hindu family and social reform in the sense of reorganization and restructuring of the Hindu society. The former has relation to widow remarriage, abolition of child marriage, etc., while the latter relates to abolition of the caste system. After repelling the arguments in defense of the caste system, he asserted that caste system is not merely a division of labor, it is also a division of laborers. It is a hierarchical order based on birth, leading to stratification of occupation. The division of labor is not based on choice, it is based on birth. He concluded that as an economic organization, caste is an harmful institution, inasmuch as it involves subordination of men's natural powers and inclination to the exigencies of social rules. When Dr. Ambedkar was asked that since you have repudiated the caste system, what kind of an ideal society he would wish for? And his reply was that an ideal society would be a society which is based on liberty, equality, and fraternity. Kindly mark the words. This Ambedkar had written in 1936, liberty, equality, and fraternity. And this thought process of Ambedkar finds its full manifestation in the preamble to the Constitution of India, when these words form the essence of our Constitution. He then goes ahead to explain the three concepts, which according to him is nothing but another name for democracy. He says democracy is not merely a form of government. It is primarily a mode of associated living, of conjoint communicated experience. It is essentially an attitude of respect and reverence towards fellow human beings. Explaining the concept of equality, Dr. Ambedkar highlighted that equality is a fiction. All men are not equal. They are not born equal. Men's ability and power is dependent upon, number one, physical heredity, his social inheritance or endowment in the form of parental care, education, etc. He then posed the question, do we treat unequal men as unequal merely because they are unequal? Should we not do anything to have substantive equality? Therefore, he suggested that it would be desirable to give incentives for full development of those who are less equal. He gave an analogy of a race and answered that individuals in whose favor there is birth, education, family, etc., would be selected in the race. But such a selection would not be a selection of the able. It would be a selection of the privileged. Therefore, it was necessary that the rules of the race were required to be changed to bring about an equilibrium so as to make the competitor equal in the race. Friends, when we talk about equality, you must read Articles 15:16. 15:1 and 16:1 are principles of formal equality, whereas Articles 15:4 and 16:4 espouse substantive equality, advancing the cause of social justice. When we talk about these two provisions, it is natural that the question of reservation in education and in public employment would come to the fore. The earlier view of the Supreme Court was that reservation was a social necessity. Therefore, it is an exception to the principle of merit. 15:4, 16:4 were exception to the equality principle, general equality principle in 15:1 and 16:1. Therefore, there was some kind of a binary between merit and reservation, where reservation becomes antithetical to establishing meritocracy. If you have reservation, you sacrifice merit. If you want merit, you can't have reservation. There was a binary sought to be advanced. Supreme Court also, if you look at the earlier judgments, generally subscribed to this viewpoint. Thus, affirmative action was seen to be a deviation from the principle of formal equality. It is not that such a dominant view had gone unchallenged. Justice Subbarao, who is often referred to as a perennial dissenter in Indian judicial system, even when he became Chief Justice of India, he started writing dissenting judgments. In fact, Justice Rohington Nariman has brought out 2 volumes of dissenting judgments in India, starting from 1950 right up to, I think, 2010 or 2015, where the pride of place prominence finds Justice Subbarao. In T. Devadasan, that's a 1964 judgment, in his dissenting judgment, Subbarao said that Article 16:4 is not an exception, but is a facet of Article 16:1, which seeks to redress the historical disadvantage suffered by certain communities. While giving his reasonings, he gave the analogy of a horse race. 2 horses are set down to run a race. One is a first-class racehorse, the other an ordinary one. Both are made to run from the same starting point. Though theoretically they are given equal opportunity to run the race, in practice, the ordinary horse is not given an equal opportunity to compete with the racehorse. Indeed, that is denied to it. So a handicap may be given either in the nature of extra weight or a start from a shorter distance. By doing so, what would otherwise have been a farce of a competition would be made a real one. Then he goes on to the centuries-old oppression and submission suffered by a large segment of the Indian populace, and refers to the words employed in Clause 4 of Article 16, more particularly the expression nothing in this article, and says that this is a legislative device to express the intention in a most emphatic way that power conferred under Article 16(4) is not limited in any way by 16(1). It has not really carved out an exception, but has preserved a power untrammeled by the other provisions of the Act. Now, just look at the analogy given by Justice Rao. It has a striking resemblance to the analogy given by Dr. Ambedkar in his Annihilation of Caste. This minority view of Justice Subba Rao in T. Devadasan was finally accepted by the Supreme Court in 1976 in the case of State of Kerala versus N.M. Thomas. This decision, N.M. Thomas, has transformed the equality jurisprudence in India from that of formal equality to substantive equality, and thus changing our understanding of reservation. Equality of opportunity for unequals can only mean aggravation of inequality. Therefore, differential treatment in the standards of selection is within the concept of equality. From N.M. Thomas, Supreme Court has accepted that special provisions, affirmative action made for the benefit of any class is not an exception to the general principle of equality. Such provisions are a method to ameliorate the structural inequalities that exist in the society, without which true or factual equality will remain illusory. In that famous Mandal case also, Indira Sawhney versus Union of India, a 9-judges bench approved this principle. And very recently, in the case of postgraduate admission in medical colleges under NEET, Supreme Court in Neil Aurelio Nunes has finally concluded that the crux of the above discussion is that the binary of merit and reservation has now become completely superficial. An open competitive exam may ensure formal equality, where everyone has an equal opportunity to participate. However, widespread inequalities in the availability of and access to educational facilities will result in the deprivation of certain classes of people who would be unable to effectively compete in such a system. A combination of family habitus, community linkages, inherited skills work to the advantage of individuals belonging to certain classes, which is then classified as merit, reproducing and reaffirming social hierarchies. Special provisions like reservation enable such disadvantaged classes to overcome the barrier they face in effectively competing with forward classes and thus ensuring substantive equality. Supreme Court has finally said that we cannot have arid equality, desert-like equality, which does not take into account the social and economic disabilities and inequalities from which large segment of our populace suffer. Equality in law must produce real equality. De jure equality must ultimately find its raison d'etre in de facto equality. So post N.M. Thomas, there is no constitutional basis to advance any kind of argument that there is a binary of merit and reservation. Both are complementary to each other. Friends, we proceed to the next concept, that is democracy. We have already seen democracy has been held to be a basic feature of our Constitution, which includes parliamentary democracy and the principle of free and fair election. Parliamentary democracy generally envisages representation of the people, responsible government, and accountability of the Council of Ministers to the legislation. The essence of this is to draw a direct line of authority from the people through the legislature to the executive. The edifice of democracy in our country rests on a system of free and fair election. Periodic elections to the Lok Sabha and the Vidhan Sabhas on the basis of universal adult franchise form an integral part of the democratic process. We have a constitutional body, the Election Commission of India, with great deal of autonomy, which conducts the election. With one decision after the other, I need not go into all this decision, Supreme Court has empowered, strengthened the Election Commission of India. But we need to pause here and ask ourselves a question: is democracy all about elections? Is democracy all about winning elections? Is elections the be-all and end-all of democracy? Let us go back to the preamble. One of the fundamental objects of our Constitution is to constitute India into a democratic, secular, socialist republic, and thereby secure to its citizens justice, liberty, equality, and fraternity. As Dr. Ambedkar has said, democracy is a way of life, a way of thinking, cultivating respect and fraternal feelings for fellow human beings. Therefore, democratic ideals and thought process must permeate the individual, the family, and the community. But we need to ask ourselves, each one of us need to ask ourselves, we need to look within. Are we truly democratic in our daily lives? How we conduct ourselves at home, how we conduct ourselves outside, at the family level, at the community level, are we truly democratic? The morality that we practice at home, the morality that we practice at the community level, often deviates from the mandate of the Constitution. So much so that we now talk of constitutional morality, because our morality has not reached the stage of morality which the Constitution wants each one of us to rise above us and achieve that kind of morality. That is the ideal, and that is the ideal what the preamble says. Coming back to the central theme of democracy, I am of the view that it is like an unbroken chain comprising several important segments. According to me, there are 5 Ds in a democratic process. Stage 1 is divergence of views. It means there can legitimately be different views or opinions on an issue. Plurality of thought process is welcome. The second stage, difference. When there is a plurality of views, there is bound to be difference in substance and procedure. From divergence of views to difference, we now come to the third stage, dissent. Such differences can lead to dissent. Dissent is healthy in a democracy. Unless the dissent leads to violence or communal disharmony or sedition, it should not be criminalized. The fourth stage is dialogue. We must encourage discussions or debates between people and groups having divergent views. And dialogue is a continuous process, should be encouraged. After we have divergence of views leading to differences, then dissent, and then dialogue, the final stage is the decision. It is the final stage of the democratic process. It must be an informed decision, not a decision which is imposed from the top, trickle-down effect. It must be a decision where all the views of the stakeholders are taken into consideration and an informed decision is taken. So, friends, we have traveled the journey, albeit on the one side of the journey, there are very many other issues also. We have traveled how the doctrine of basic structure has evolved in this country. from the basic structure, we have seen how equality and democracy are now the basic features of the Constitution. This cannot be amended or wished away because it will need a Constitution amendment. And since this strikes at the basic structure, perhaps such an amendment may not be possible. I think I have spoken enough. So I need to wind up. Everything, whether it's good or bad, must come to an end. One more thing. But before I end, before I part, I would like to remind myself and remind all of you as to what Dr. Rajendra Prasad had said during the concluding session of the Constituent Assembly. We go back to the Constituent Assembly again, where the great minds of our founding fathers deliberated upon and gave us this vibrant document. As the President of the Constituent Assembly, he concluded the session of the Constituent Assembly by observing, and I quote his words, "We have prepared a democratic constitution." This is Rajendra Prasad saying. "We have prepared a democratic constitution, but the successful working of democratic institutions requires in those who have to work them willingness to respect the viewpoints of others, capacity for compromise, and accommodation." I repeat once again, these are prophetic words of Dr. Rajendra Prasad. "We have prepared a democratic constitution, but the successful working of democratic institutions requires in those who have to work them willingness to respect the viewpoints of others, capacity for compromise, and accommodation." Thank you very much for giving me a patient hearing. It was a pleasure to be amongst all of you in this USTM University. Thank you very much, and God bless.
Thank you so much, Honorable Sir, for such an eye-opening talk.